Let's rewind history a bit. Back in ancient Babylon, under the court of Hammurabi, around 1750 BCE, merchants could cancel loans if the ship sank. That's money insurance. Or as it was back then, a very serious form of betting against the sea. By the time we reached Lloyd's Coffee House, 17th century London, traders literally sat around tables, betting on ships. Some never saw the ocean. They just hoped a storm will swallow someone else's vessel. Because that meant profit. That's great. And this budded law and law birthed the British Marine Insurance Act of 1745, which made insurable interest mandatory, the thin legal line that transformed gambling into risk management. When Britishers left India, they brought that line with them. And thus the Insurance Act of 1938 was born. So insurance versus gambling. Insurance must exist. It's personal. Gambling, not at all. Insurance. Protection against actual loss, but gambling is profit from pure chance. Insurance. Premium for indemnity for gambling. Mutual promise to pay. Insurance. Compensation for real damage. Gambling. Payment regardless of loss. Insurance. Valid and enforceable. Gambling void under Section 30 of the Contract Act. Insurance. Socially beneficial. Gambling. Morally speculative. And yet, when you strip away the studies, the moral sugarcoating, they look eerily alike. Book by women certainty, put a price tag on the future, people saying, if this happens, I get paid.
So, are we different from gamblers or just better dressed?
Let's fast forward to the 21st century. Finance found a way to gamble again legally. Enter derivatives, options, credit default swaps, all the fancy names for betting on the finance events.
When used for hedging, their insurance. When used for speculation, their wages.
And during the 2008 global financial crisis, we saw the thin line shatter. Banks were literally insuring companies they didn't own, hoping they would collapse. It wasn't protection, it was profit from downfall. In India, the Securities Contract Regulations Act 1956 draws the moral boundary. If your financial bet happens on a recognized exchange, it's lawful. If it's off the books, Section 30 calls it void. Once again, law transforms morality into paperwork.
The philosophical twist. Let's step back. Both gambling and insurance exist because humans crave control in chaos and chaos in control. The gambler says, I will beat the odds. Insurance says, I will prepare for them. One rolls dice, the other drafts a policy. Both are acts of fate, just aimed at different gods. That's why philosophers call insurance moral gambling. You still wager, only this time you dress your risk in legality and paperwork. As I like to say, the law didn't kill the wager, it just gave it a license and called it protection. Case Chronicles. Let's run this paradox in the courtroom. In Gerulal Praka versus Mahadev Das Maya, 1959, the Supreme Court said wagering isn't illegal, it's just unenforceable. So while you can bet, you cannot sue for it. Meanwhile, in Makura versus Northern Assurance Company 1925, a man insured a timber company's property in his own name. When the timber burned, the court said you had no insurable interest. Company owned it, not you. Result, policy wise. And then came Lakira versus Crawford, 1806, defining insurable interest itself. A person must benefit from the preservation or suffer from the loss of the subject matter. Without that bond, it's gambling. With it, it's law. So here we are, centuries later. Insurance companies still bet, but with legal blessing. Gamblers still dream, but without legal standing. Maybe the difference isn't moral at all, it's administrative. Society calls one vice and other virtue because one pays tax and the other doesn't. Let's face it, insurance didn't end gambling, it professionalized it. A gambler prays for loss, an insurer prepares for it. Section 30 gets the wager, but not the instinct to bet. is the moral casino of capitalism. So next time you renew your policy, remember, you are still playing the odds. That's legally. And that's the beauty and the hypocrisy of our modern law. This is rightness first, where we don't just read the law, we read in between the lines. Subscribe for more legal paradoxes because truth, like law, is always game of chance.